The Supreme Court of Canada has made it clear that as long as you are allowed some private use of your property, even if that use is not very valuable, and even if the value of your land has been drastically reduced by regulation, you're not entitled to compensation. When a person has an expectation to derive some benefit or advantage from some land, and that expectation is backed by the legal system, then we say that that person has a property interest or right in that land. And the responsibility of the legal system is to manage those different expectations as best as it can. Over the last few years, it became apparent that there's a great deal of confusion among Albertans as to which expectations with respect to land are going to be protected. And the two most common questions are just how far can the government go in regulating my land? And second, will I have recourse to the courts, and will I be entitled to financial compensation for such regulations?
In the last 6 years, the Alberta government has passed a lot of legislation which many people have viewed as imposing serious restrictions on the right to use property. And what struck me about that when the legislation first came out was the enormity of the disconnect between what people believed property rights were and what the law actually said property rights are.
Many of these initiatives are new and unfamiliar to owners, and owners are asking, is this a legitimate government action? What we're trying to do is to clarify some of this confusion, sort through it, and we're going to begin by publishing a document that will bring some order into this confusion, lay out some of the background, the context for the Canadian legal system, the legal framework within which property rights are situated. And we hope that that document will be of assistance to stakeholders, affected owners, etc.